Au Comité Permanent des Affaires Sociales.
Welcome to the Standing Senate Committee on Social Affairs, Science and Technology.
Topic of Bill C6, an act respecting the safety of consumer products. We have two lawyers who are here at the table with us. Since a lot of the focus on C6 has been on different provisions in the bill. We have two of them to give us some advice in that respect. Shawn Buckley is a lawyer, a constitutional lawyer, as it notes here, but he's written extensively on the subject of C6 and some of its predecessor legislation. Cindy Cherniak is a law professor. She's a counsel at Lang Michener, involved in international trade law, and she's also an adjunct professor at Case Western Reserve University School of Law in Cleveland, Ohio. Is that correct? I got that right? Okay. Well, thank you very much to both of you for coming. And Mr. Buckley, you're going to start. We've got two of you, so I think about 10 minutes each, and then we'll enter into dialogue and questions.
Thank you. I'm going to take more of a legal philosophical approach, which is where my interest in this bill lies. And it lies there because I have actually some very significant concerns about where we're moving and the precedent that this is going to set. And it's interesting because we're dealing with a safety bill. This is to protect consumers. And it's very hard to resist safety legislation. And yet, when I look at the bill, I have to tell you that it actually raises, in my mind, safety concerns from a legal philosophical perspective. And I didn't always feel that way. My first introduction to the bill was, like everyone else, I think, through government advertising. Back before the prior election, this bill was C-52, which was really the same with a few minor changes, primarily in the area of privacy. And I'm sitting down reading my newspaper, and there's a half-page ad with pictures of cute, vulnerable-looking kids and this caption, protecting you and your family. And it was purely designed to evoke an emotional response. And it did evoke an emotional response. I felt proud that my government was going to do something to protect us. But then when I was asked to look at the bill, the first question I asked myself was, okay, do you mean today in Canada we do not have legislation to protect consumers? Do you mean the government can't step in and effectively, if a product is dangerous, intervene? Obviously, when I started to look at it, I found that there were overlapping pieces of legislation. I mean, the most obvious one is the Hazardous Products Act, and I will concede that this act goes further than it does. But the Hazardous Products Act is a fairly effective piece of legislation if the government finds that there's a significant risk. But where it differs is there's procedural safeguards when property is seized. We've also got the Competition Act covers some areas here. Clearly the Criminal Code covers some areas. And I think that we would be amiss if we ignored the civil law, tort litigation, which actually historically has been the biggest brake on the use of consumer products that are unsafe. So I'm looking at this legislation and I'm realizing, well, first of all, yes, it has some features that aren't in other legislation, but those features could be added without actually changing our legal philosophical landscape. Because when I looked at the bill, what first alarmed me was what I call is a move away from the rule of law. Now, when I say rule of law, I don't mean it in a technical lawyer sense. A lawyer will view a rule of law as a legal principle that is so accepted that we expect courts to follow it without discretion. When I say rule of law here, I mean it more as a citizen would interpret it. And a rule of law as a citizen would interpret it is that a person's body or a person's property cannot be interfered with by the state without supervision by the courts. And when I lecture on this topic, I basically, to make it simple for people, I just ask them, I say, well, imagine going back in history before we had courts interceding between the person and the state. And if the ruler wanted to imprison you, the soldiers just came and dragged you into the dungeon and that was it. Or if the ruler wanted to take your property, the soldiers would just come and take your property and that was it. We didn't have courts, we didn't have procedural fairness. And revolutions were fought on this issue. So it's actually a very significant legal principle that we have in Canada, that before the state can interfere with you as a person, or before the state can interfere with your property in a significant way, they have to go through the courts, and the courts adjudicate between the citizen and the state. Now that's what's changing with this bill, and that's what's alarming me. And there are a lot of administrative acts that will allow the state to seize documents, and courts don't seem to be very concerned about that if they're pursuing legitimate administrative purposes. There are a lot of acts that allow the state to temporarily interfere with property. But this takes it to an entirely new level that I think creates a very dangerous precedent. So when we look at Section 20 of the Act, the seizure powers, and I could ask rhetorically, well, what's the time limit for a seizure when an inspector seizes property? And the discretion to seize property is extremely wide. There doesn't have to be a safety concern to seize property under this Act. I could rhetorically ask, well, are there any limits on the amount of property they can seize? No, there's no limits. Do they have to report seizure to a court? No, they don't. So if they charge you with an offense, then a court is all of a sudden perhaps going to supervise the property once they get to forfeiture proceedings at the end. But you have to understand, this is a bill being built to protect, people and their families. If you own a family business, an inspector can walk in and effectively take control of your business, ruin you financially over regulatory violations that may have nothing to do with safety. That's the reality of this bill. Now, if your property has been seized for them to check for compliance or for them to enforce compliance, and as I say, they decide to charge you criminally, they're not going to be able to forfeit your property without a court intervening. But if they charge you administratively, it's a different story. If you look at Sections 30 and 31 of this Act, Section 30 allows them to order you to recall. Section 31 allows them to actually make broad orders. They can order you to stop sale, or they can basically order you to do anything necessary in the inspector's opinion to assumedly bring you into compliance with the Act. So let's imagine you are a small family business and an inspector has found some violation that doesn't really create a safety risk and has taken control of your business and has decided, well, we're not going to charge you criminally, and they issue an order against you, and you don't adhere to the strict letter of that order, and you're charged administratively with violating the order. You don't get to go to court. There's no way under this Act that you could have a court review that order. In fact, you don't get to present any evidence orally, anything under oath. You are restricted to submitting writing to the minister, and in fact the Act prohibits the minister from considering anything but writing. You are not presumed innocent until you're proven guilty beyond a reasonable doubt. You are applying to the minister. If you don't do anything, you're just presumed guilty. You've been issued this violation ticket. You do nothing, you're presumed guilty. But you've appealed to the minister. The minister now decides whether you're guilty on the lower civil standard of balance of probabilities. The two main defenses that you would have in an administrative law context, due diligence and honest but mistaken belief, are taken away from you under the Act. You are not actually reviewing whether the order was reasonable, whether there was a health risk. The minister's only reviewing whether or not you adhered to the order. And that's actually very important for you to consider. The minister is only allowed to consider whether or not you violated the order, not to look behind the order and see if this was reasonable or justified or excessive. Now, if the minister determines on a balance of probabilities that you are guilty, then the Act, Section 61 of the Act, allows the minister in his or her discretion